Hoy vamos a dar inicio a el taller. Le pedimos al profesor Rachlinski que nos pudiera dar un taller un poquito ya para entrar en cuestiones más metodológicas sobre las investigaciones que ha estado haciendo y sobre todo cómo medir los sesgos cognitivos, cómo también poder avanzar hacia técnicas, en inglés se llama de bias, ¿no? De tratar de neutralizar estos sesgos, que creo que hay un interés importante por parte de nuestro equipo de investigación y probablemente también por parte de muchos de ustedes. Entonces, el taller va a tener una duración aproximada de 3 horas. Vamos a tener ahorita un primer periodo más o menos como de 1 hora 20, después vamos a tener una breve pausa de 15 minutos y después vamos a tener también como 1 hora y media en la segunda parte. Entonces, el profesor Rachlinski es el que va a estar liderando ambas partes y bueno, y lo que quisiéramos es que también pudiera ser como una sesión muy interactiva, ¿no? O sea, con sus preguntas también, si están haciendo investigaciones específicas o tienen temas específicos que quieran trabajar y que quieran abordar, creo que sería un muy buen espacio para poder hacerlo y para poder también aclarar una serie de dudas. Y bueno, lo que pensábamos es que tal vez para iniciar y no quitarnos mucho tiempo, tenemos 5 minutitos todavía antes de que empiece el horario oficial del taller. Quisiéramos tal vez hacer una breve presentación. Are you okay with that, Jeffrey? If everybody just presents themselves very quickly and just exposed what are you working on or what institution or faculty are you from, ¿ya? Perdón, entonces les vamos a pedir eso, que tal vez hagamos una presentación. El día de hoy está considerado más como taller y es un taller donde aceptamos a menos personas exactamente para poder trabajar de mejor manera. Entonces les vamos a pedir muy rápidamente que nos digan su nombre, que nos digan la institución de la que vienen y en 2, 3 palabras, ¿no? ¿Cuál es su interés de estar aquí el día de hoy en este taller? ¿Les parece bien? Nos ayudan con los micrófonos, tal vez Cincy, Gil, ¿quién anda por ahí? Si quieren, empezamos rápidamente de este lado. Habla fuerte. ¿Sabes qué? Nada más por la traducción, creo que sí necesitamos el micrófono.
Yo soy el maestro Sergio Guillén, estoy en la Facultad de Derecho y esos son temas que me interesan profundizar para poder ver la viabilidad que hay en nuestro país para confrontar este tipo de iniciativas, ¿no? Bien.
Muchas gracias.
Buenos días, mi nombre es Jaime Rivera. Yo estudié Literatura y Letras en la Facultad de Filosofía y Letras y me he dedicado a la edición de libros, a corrección. Entonces, últimamente pues he estado estudiando lo que es derechos humanos y todo, pues lo que corresponde a mi área, ¿no? Que es la edición de libros. Por eso me interesa. Gracias.
Buenos días, yo soy Benjamín del Olmo, soy trabajador social y soy abogado especialista en derecho burocrático, soy activista sindical por la burocracia. Más que nada mi investigación va destinada mucho en el funcionamiento del sistema laboral, por eso tenía tanta inquietud en conocer el tema. Gracias.
Hola, mi nombre es Claudia Rangel, yo provengo de la Facultad de Psicología y mi interés por estos temas es porque busco dedicarme al trabajo de los derechos humanos y estudiar la discriminación en poblaciones vulnerables.
Hola, buenos días, mi nombre es Patricia Santaella, maestra en Psicología y trabajo un proyecto que se llama INCIDIS, Interacciones sin Discriminación. El objetivo del proyecto es justamente trabajar la prevención de la discriminación y la violencia con diferentes poblaciones, pero algo que no se ha realizado en el proyecto es la medición. Entonces, cómo desde la cotidianidad se va dando estos procesos de injusticia y de repente pues a otros niveles ya no la exigimos y ya no la hacemos valer también como actores o como de impartición o como sociedad. Entonces me interesa mucho el tema, por eso es que estoy aquí. Gracias.
Gracias.
Buenos días, mi nombre es Susana González, soy psicóloga de la Facultad de Psicología y trabajo aquí con el doctor Enrique Cáceres Nieto en un proyecto de toma de decisiones en jueces. Creemos que una de las variables que influyen en las tomas de decisiones de los jueces son los sesgos cognitivos, entonces es por eso que estamos interesados en este taller.
Hola, buenos días. Mi nombre es Leonardo García, maestrante de posgrado en estudio en la FES Aragón de la UNAM, y pues mi interés en el tema es de que siempre he seguido el tema de derechos humanos, y por medio de la cultura, la actualización de diversos temas, reforma del Estado, y aprovecho todos y cada uno de las conferencias que pues me brinda la Casa de Estudios, y constantemente estoy en conferencias, talleres, seminarios, mesa de debate, aprovechando todos y cada uno de los seminarios. Es cuanto.
Allá atrás, Gil, si quieres, antes de venir de este lado, aquí con él.
Buenos días, voy a hablar en español. Yo soy investigador de aquí del instituto, soy responsable del laboratorio de constructivismo jurídico complejo, cognición, complejidad y derecho. Entonces hemos estado trabajando junto con Susana, que es parte de mis grupos de neurocientíficos, en trabajos de correlatos neuronales, cuando los jueces toman decisiones, resolviendo dilemas jurídicos y dilemas jurídicos morales. Entonces el interés es complementarlo con lo que estás haciendo en la teoría de los sesgos y muy probablemente ver si podemos replicar tus investigaciones en el entorno cultural de México. Ayer es una de las cosas que estuvimos comentando. Muy buen día y bienvenido.
Muy buenos días, muchas gracias. Mi nombre es Eric García López y yo soy investigador. Trabajamos en el área de psicología jurídica y neuropsicología forense, y nuestro interés también justamente está en identificar las estrategias metodológicas, aprender de ellas para fortalecer esta línea de trabajo aquí en México.
Muy buenos días, mi nombre es Víctor Sandoval, vengo de parte de la Oficina de las Naciones Unidas contra la Droga y el Delito. Bueno, vengo porque parte de mis labores tienen que ver con entrevistas a jueces, y me interesa mucho conocer cuál es su proceso de pensamiento. También tengo un pequeño artículo publicado sobre sesgos cognitivos desde la psicología jurídica en español. Entonces, pues bueno, de ahí mi interés en la conferencia.
Buenos días, mi nombre es Libertad Merchán, estudiante del doctorado en la Facultad de Psicología de aquí de CU, psicóloga perito, y interesada también en estos temas de investigación con la finalidad de poder replicar o hacer investigación en estas áreas. Gracias.
Hola, buenos días. Soy Alejandro Rodríguez. Estudié filosofía, estoy estudiando derecho y trabajo el fenómeno del desacuerdo en epistemología, derecho y psicología.
Hola, buenos días. Mi nombre es Natya Nava. Soy de la Facultad de Economía de la UNAM. Estoy trabajando mi tema de tesis acerca de la automedicación en México y estoy interesada principalmente en cómo la teoría de los sesgos cognitivos puede ser ocupada en este tema. Gracias.
Hola, buen día. Mi nombre es Valeria Padrón. Soy contadora, tengo una maestría en fiscal, me dedico a la parte de impuestos. Y mi tema de doctorado actual es sesgos cognitivos en la tributación. Ese es mi interés en las conferencias.
Buenos días, mi nombre es Rogelio Sánchez, de la Comisión de Derechos Humanos del Estado de Morelos, soy abogado y acabamos de crear una nueva área que es investigación y estudios de los derechos humanos, entonces por eso estamos aquí, poder aportar y replicar. Gracias.
Buenos días, soy Rafaela Bernabé, egresada de la Universidad Autónoma de Tamaulipas y actualmente soy maestrante en psicoterapia cognitiva. Llevo 15 años trabajando en el sistema gubernamental y ahorita estoy ejerciendo como psicoterapeuta cognitivo-conductual.
buenos días, soy Jazmín, soy recién egresada de la Facultad de Psicología del área organizacional y voy a iniciar mi tesis de licenciatura de ¿es el tono de piel una característica que impacta en la selección de personal de México? Entonces estoy interesada en este taller.
Buenos días, mi nombre es Patricia Durán, yo soy educadora, maestra de pequeños de jardín de niños y también soy licenciada en sociología. Entonces mi interés, digamos, que va sobre 3 puntos. Uno es para poder replicar estas situaciones de inclusión y de no discriminación desde los niños muy pequeños, empezarlo a manejar ya con ellos. La otra situación es que, bueno, yo personalmente quiero reconocer los sesgos cognitivos que yo tengo cuando actúo personalmente en la cotidianidad y a nivel laboral. Y el otro punto es que tengo una hija que está estudiando actualmente licenciatura en ciencia forense, entonces me interesa también poder apoyarla y poder entender todo lo que ellos están manejando para que sea una mejor profesionista también. Gracias.
Hola, soy Verónica González Plata, soy defensora de derechos humanos y por una situación personal donde fui juzgada por ser mexicana me dediqué a estudiar derecho y estoy documentando casos sobre mujeres latinas en Estados Unidos que son juzgadas por el simple hecho de ser latinas.
Buenos días, soy Montserrat Hernández, estoy estudiando la maestría en finanzas aquí en la universidad. Y mi tesis es referente a los sesgos cognitivos y los ahorradores mexicanos, es por eso por lo que estoy aquí.
¿Y los oradores? Ahorradores.
Hola, soy Cincy, yo colaboro con Alexandra en el programa universitario de Derechos Humanos y mi tema va enfocado a migración forzada y sesgos cognitivos.
Hola, ¿qué tal? Mi nombre es Margarita, también trabajo con Alexandra en el Hub de Derechos Humanos. Y mi interés es cómo afectan los sesgos cognitivos en la implementación de políticas públicas. Yo estudié Ciencias Políticas y Administración Pública.
Buenos días, mi nombre es Odette. Hago el voluntariado también con Alexandra en el PUD. Y bueno, soy egresada de Ciencia Política y Administración Pública.
Hola, yo soy Gilberto Martínez, egresado de Sociología por la FES Acatlán de la UNAM, e igual trabajo en el Programa Universitario de Derechos Humanos como parte organizadora.
Pues bien, muchísimas gracias. Creo que tenemos un grupo muy diverso, ¿no? Y además con intereses muy específicos también, entonces creo que va a ser una sesión muy interesante. Así que ya para no alargar más el inicio de este taller, le damos la palabra al profesor Jeffrey Rachlinski. Muchas gracias, Jeffrey.
Buenos dias, good morning. Thank you all for coming. My wife claims that 2 days of listening to me is torture, so thank you for bearing with me. It's an astonishingly diverse group, so I hope there's something here for everybody. We will do our best. As far as the format goes, Alexandra sent me a number of questions after yesterday's talk. From her research group, and I've tried to organize a presentation around those questions that adds a few things, that expands on them a little, that hopefully gives us something for everybody and addresses the questions. I am prone to simply keep speaking without being interrupted, which I don't think is necessarily the right format for this. So if I'm going to count on Alexandra to perhaps to slow me down and stop and get audience participation at various points in the presentation, if that's acceptable to all of you. But if you have a question, raise your hand. I may not see you. I'm counting on Alexandra to stop me if you raise your hand. So just be aggressive about that at any point that you have a question. One thing, to two of you said you were studying judges directly. I'm going to ask at the outset, please contact me. I'd love to exchange work with both of you. I'm very, very easy to find. There's no one else on the planet named Jeffrey Rachlinski. So, okay, well, so yesterday's talk was largely focused on my research on judges, really with the theme of showing that judges are prone to rely too heavily on intuitive, quick responses to the people and to the case facts that appear before them. And that this creates a particular problem, gracias, which is that they then rely too heavily on their intuitive reactions, and it produces errors in judgment. Yesterday in the question and answer, I tried to identify, or categorize rather, those errors as sort of cognitive errors, ones involving deductive logic about the case facts themselves, and others involving errors about judgment about people. So today I've tried to focus more on remedies. Alexandra asked, well, could you give us some solutions, some remedies for judges? Emphasizing again the point that for many people in most societies, justice is what the judge says it is. An individual appearing in front of a judge is reliant on that judge for sound discretion, good judgment, and a humane treatment. And so for me, my research is focused on judges because they're the important point of most systems of law. Whatever happens at higher courts in particular or in front of the legislature gets translated into justice at the trial level. And if it's unfair, if it's inaccurate, if it's biased in a particular way, then the system of justice simply doesn't function. So for me, judges are very central. So remedies for the kinds of problems I've identified, I think are in fact quite important. Most of the time when I speak to judges, they ask more or less the same question, which is, okay, I'm convinced we make mistakes, we're human beings, now how do I do better? And actually, we do a lot more work trying to convince judges that they make mistakes than trying to improve their decision making, because getting their attention is really the first step towards making better judgments. But we do have a fair amount of work on remedies, and so I'm trying to focus on that today. All right, so debiasing is really the common theme behind remedies. If we think that the source of many errors or biases that judges have are cognitive at the core, that they're the intuitive, system one, quick, rapid reactions, if that's the source of error, then finding different cognitive strategies to debias them so they make judgments that don't rely too heavily on their intuition is really overall the right approach. But often a debiasing strategy depends on understanding the cognitive mechanism that produced the error in the first place. And often a debiasing remedy can be quite specific. So I'll start with an example. Yesterday I spoke a lot about a phenomenon called anchoring. Anchoring, again, is the reliance on numeric reference points when making numeric judgments. And it tends to involve judgments involving numbers. Many judges actually at this point typically will say, well, I'm willing to admit that I'm not very good at numbers. Part of why I became a judge. But the truth is judges must deal with numbers. Civil damage awards, all numbers. Criminal sentences, numbers. They have to deal with numbers. And in our research, we've shown that judges are prone to making significant errors when they, in fact, have to identify a criminal sentence or a civil damage award. And anchoring is a primary source of that error. So we have worked on debiasing with anchoring. And so let me give you an example of how we've tried to debias judges. We gave judges a hypothetical fact pattern, which is our primary research methodology, involving an automobile accident. We told the judges the accident was the defendant's fault. The defendant has admitted that they were liable. And the defendant is a large company. They're a package delivery service. So they're going to pay some damage award. They've got the money. The plaintiff, we said, was very severely injured. He lost his dominant arm, his right arm, in the accident. The accident is the defendant's fault. And so we're looking for an appropriate damage award for this. The victim here, the plaintiff, was said to have been in the hospital for several weeks, suffers a lot of anguish over the accident, can't use his no dominant arm anymore. There are many things he can't do. He was an electrician. He's having a great deal of difficulty reconstructing his profession, so he's very badly injured. I'm sorry, this was a teacher. He still can teach, but it's a problem for The numeric anchor for the judges arose from settlement talks. So we told the judge that he'd presided over a settlement conference at which the parties were trying to determine an appropriate damage award. We tell the judge the case didn't settle, but that the parties spoke about numbers in the settlement talks, and that creates the anchor. What we tell the judges is that during the settlement talks, the plaintiff, the victim, mentioned as an aside that he recently saw a case on a court television show. We used this yesterday with a different problem, where a victim like me received and we put a number in here, a damage award. For some, it was a pretty low anchor, $150,000, which would be a pretty modest award for this injury in the United States. Or we said, we didn't give them an anchor, just said a damage award, so no number. That's kind of our control condition here. Or a very high anchor, $10 million, which would be an inordinately high damage award for this particular injury. It's a serious injury, but that's too much. So we've got a low anchor that we thought would lower their awards. We've got a control condition in which we think we'll get whatever the appropriate measure of awards is. And we have a high anchor which we think will drag the awards up. And that's what we found. That's a replication of some of the work I presented yesterday. The control condition is in the middle, and the median damage award is basically $700,000. That seems about right. The low anchor, when the plaintiff says he watches television and someone got a small award, pulls that down. Probably shouldn't say that to the judge. And in the version where the plaintiff says he saw a large award, it pulls it up. And that's a replication. It shows that anchoring, again, is a very potent phenomenon. Now, half the judges basically saw one of these three versions. The other half saw the same anchoring effects, but we added a debiasing paragraph, the strategy. So we told the judge, it's just embedded in the materials, that the case reminded the judge of a recent legal newspaper article discussing damage awards. This was done in Ohio. And we basically identify a set of awards in there for various injuries. So we actually tell them about it refers to a case where the injury is not very severe, it refers to a modest injury, and it refers to a very severe injury, and puts damage awards on those that are more or less socially appropriate. So the awards in this paragraph are reasonable awards for the injuries they describe. And what we're trying to do for the judges is essentially recalibrate them so that they have a good way of translating the injury into a dollar award. Now, translating a physical injury into a dollar award is challenging for judges. In the United States, it's challenging for juries as well. There are no fixed metrics for doing so. People have to basically use their impressions. That's very much a System 1 intuitive process. But here we gave them fairly good translations. But we also, remember, gave some of them some very misleading translations in the anchor. So what we wanted to do is see whether this debiasing strategy, where we give them reasonable anchors, basically unbiased or debiased the effect of the anchor. And mostly yes was the answer to that. Actually, it seemed to increase the awards overall, which was troublesome for our because that was not our intent. We kind of wanted the awards to end up in the middle. But the awards did go up a good deal, but they did become more uniform across the conditions. So when the judge had both read the debiasing paragraph and was exposed to the misleading anchor, the judges weren't nearly so erratic, didn't give such high awards as when they had not been exposed to the debiasing condition. So the lesson we draw from this is that the way anchoring works is it kind of distorts one's sense of scale. So that if a judge is inclined perhaps to give an award of $700,000, and then that judge hears about another case in which the award was much smaller, $700,000 seems too big. Intuitively, it feels too large, so they lower their award. But when we've rescaled them, when we've given them basically a translation index of how to convert damages into dollars, then that eliminates that impression that the awards are too high or too low, thereby debiasing the anchor. We think this is a pretty useful strategy for judges. It's a little hard to implement in practice. What we tell judges is to rely more heavily on their experience in other cases, to try to think of injuries that were similar, think of appropriate damage awards, and remember how one actually does this translation and not be misled by the numbers that are in front of them. That more or less undoes much of the bias for anchoring. But what this shows you, if you're concerned about judicial bias, is really just how specific sometimes the remedy has to be. We really have to sort of understand how the cognitive mechanism works to figure out what a good debiasing strategy might be. Okay, that's one. Alexandra asked us about something called confirmation bias as well, which I didn't talk about yesterday, but I'll explain here. Confirmation bias is a particular problem for systems of justice in which prosecutors and judges are more inquisitorial, where they control more of the process. In the United States, the process is actually largely controlled by the parties themselves. Judges are much more passive. They review the evidence that's presented to them. They do have some influence over it. But by and large, if a defendant or a plaintiff wants to present evidence to a judge, it's going to end up in front of the judge. In many systems, in both the civil side and the criminal side, the judges, or sometimes the prosecutors, or sometimes both, depending on the system, have much more control about what constitutes evidence. And that creates a real problem that psychologists have identified as the confirmation bias. Confirmation bias is actually fairly intuitive, although the demonstrations of it are a little complicated. The intuition is that there's a tendency to seek out evidence that's consistent with one's own beliefs and to ignore, dismiss, or selectively interpret evidence that is contrary to one's beliefs. The idea here is very much that information that is consistent with what you already know is comfortable. It doesn't require a lot of cognitive effort to process information that's consistent with what you already believe about the world. Inconsistent information requires a lot of work to integrate, and so people tend to ignore it or discount it or avoid it altogether and look for information that's consistent. And it can lead to some logical fallacies of judgment. It can lead to real defects in logic. This is a little cartoon. It says, everything you look for and all that you perceive has a way of proving whatever you believe. Right? That's the confirmation bias. Just looking at now, the demonstrations of it can get to be very complicated. And so this is a classic demonstration done by a psychologist in England named Watson. And he gave his research subjects the following task. He says, here are 4 cards. And on each of the cards, on one side is a letter, on the other side is a number. And here's a hypothesis or a proposition that if there's a vowel on one side of the card, then there's an even number on the other side. And he asks his research subjects to test this hypothesis with the 4 cards he has laid out. And the basic story is you should turn over only those cards that you need to fully test this hypothesis. Okay, and no more. So many undergraduates say, well, I'll just turn them all over and then I'll know. No, that's not the game. The game is to turn over as few as necessary to prove the hypothesis. And what many people do is they turn over which cards do you need to turn over? They turn over the E card, and almost everyone does that, and that's correct, right? Because if there's a vowel on one side of the card, there should be an even number on the other side. Okay, so if you turn that card over and there's an odd number on the other side, that would obviously disconfirm the hypothesis, and so you really need to look at that card. The other card people tend to turn over is the 7, right? So that there's they tend to, because it should be a vowel on the other side, or rather, if there's a vowel on the, have I got this right? The mistake is that people tend to turn over the 4. I'm sorry. Many people will turn over the 4 and look to see if there's a vowel on the other side. Okay? If there's a vowel on the other side, that's great. It confirms the hypothesis. But here's the problem. If there's a consonant on the other side, it doesn't say anything about the hypothesis either. So turning over the 4 is a mistake. It's looking for information that you already have. Because it doesn't matter what's on the other side of the 4. But turning over the 7 is the correct thing to do, right? Because, of course, if you turn the 7 over and there's an even number on the other side, it would disconfirm the hypothesis. But people tend to turn over the 4 rather than the 7, looking for confirmation. But the 4 can't tell you anything about the hypothesis, can't really teach you anything. The 7 does, right? So you have to look for disconfirming information, right? So you got to turn that 7 over and see if there's a vowel on the other side. If there is, then the hypothesis is false. Most people get that wrong. They turn over the E and the 4, or they give up and turn over everything, which is, again, a mistake. Now, what we did for judges is we gave judges this exact problem to see how good they are at it. Because judges, of course, are supposed to weigh evidence on both sides. They should look for disconfirmation of whatever theory the parties are proposing to them. But we also gave them a version of it in which it was more translated into the legal context. So we gave them a version in which they were reading a case involving gender discrimination at the workplace. And they were we said that the plaintiff in this case was alleging that male supervisors at this company only promote male employees. Okay, and actually that has the same structure as the Wasson card selection task. It has a particular proposition to it, and it can be confirmed or disconfirmed. And we also told them they had some partial evidence about 4 different people and 4 different hiring or promotion decisions. Right, so they knew something about a male supervisor, and they could find out which employee this person had promoted, a male or a female employee. They knew about a female supervisor who had also promoted either a male or female employee. And then they knew about a male employee who was promoted by either a male supervisor or a female supervisor, and likewise a female employee who was promoted by one or the other. And we asked the judges, which of these must you investigate to determine whether that hypothesis is true or not? Again, I said this was a little complicated. And it's again, very much the card selection task. Most of the judges recognize they have to look to see who the male supervisor promoted. That's A, the first one, or number 1. Because if that male supervisor promoted a female employee, that disconfirms our plaintiff's allegation. Right? You have a counter example. But then they also looked to see whether the male employee got supervised by a male supervisor. That's looking for confirmation again. But again, it hardly matters whether that male employee was promoted by a male or a female supervisor. If the male employee were promoted by a female supervisor, the hypothesis could still be true because the hypothesis is about male supervisors and their behavior, not female supervisors. You have to look at number 4 again to see whether a female employee was promoted by a male supervisor. Okay? If that happened, it would disconfirm the hypothesis. So the judges needed to look at the cases of number 1 and number 4. That was the right answer. How well did they do? They were terrible. These are judges in the United States. These are state judges with the logical problem with the cards. And I admit I went a little quickly, so if it was confusing, I apologize. But with the cards, only 9% of them got it right. Many of them just turned over all the cards. They didn't quite get it. They were only a little bit better, however, when we put a legal context around it. It didn't seem to help them very much. They're pretty terrible at this. We've run this over and over again in different states in the United States, and we can't find a group of judges that's any good at this. We've actually run it a few times where literally none of the judges get it right. It's actually a hard presentation to give to the judges. Right? We give them this problem. They ask, well, how did we do, Professor? I say, well, all of you got it wrong. And then they get a little angry. But they're awful at this. Now, partly in the United States, I think this is a key to debiasing. Judges don't have a lot of experience with the confirmation bias. Not really. Because, again, they don't really control the evidence that's presented in front of them. So that one party or another in an adversarial system will want to present disconfirming evidence. They will try to undo the hypothesis that the other party is presenting. So the judge won't really face the kind of choice that we gave the judges. Now, we also ran this problem in the Netherlands with Dutch judges. Dutch judges, both on the civil and on the criminal side, although on the criminal side there's more cooperation with the prosecutor, but on the civil side, they really control the course of the proceedings. They control the process. They control what witnesses get presented and the like. And so they're very concerned about the confirmation bias. And they should be, because they can avoid looking at evidence that they don't want to see, much more so than judges in the United States. And they're a lot better at this problem. A third of the Dutch judges got the logical problem right. And when we put it into legal context, I'm sorry, this is all the legal context. We didn't give them the standard one. A third of them got it right. And it didn't matter whether they were brand new judges or experienced judges. It turns out, we did some research, confirmation bias is actually part of their training. Now in a way here, this is a glass kind of a third full, because 2/3 of them got it wrong. But they're just so much better than judges in the United States that I sort of regard this as a success of sorts, that these judges seem to do a lot better. Even the ones who got it wrong express kind of different confidence in their answers when we talked to them about it. They were concerned that they might be making a serious error. So this gives us a little bit of a clue to debiasing. First, it does show us confirmation bias is potentially a serious problem with judges. Looking at only information that supports what you already believe is problematic. It's very comparable to the egocentric bias in a way of how it affects judges that I talked about yesterday. If you already believe you're right, and then you only look at information that suggests you're right, you're probably not doing your job as a judge. In the Netherlands, they seem quite concerned about that. The United States, not so much. But partly there's a natural constraint in the system in the United States, so they don't really have to learn this problem as well as they do in the Netherlands. So the remedy partly here is just training about the bias. Here what we tell judges is that many of the problems you face have an internal logical structure to it. That a lot of the things what is presented to judges are a set of facts, are stories. Lawyers typically try to tell stories to judges. But these stories have a logical structure to them as well, and that we try to get judges to see through that logical structure, to look for flaws in their own reasoning, to stop and think. It's something that in the Netherlands, in their judicial training processes, they do actually work on, and so they're a little bit better at it. So when we think about then how to train judges, how do we get judges that are better, overall, I had a few questions from Alexandra. Well, how do we get judges' attention to, if judges really are prone to these kinds of errors and we want to improve them, how do we get their attention and how do we train them? First, by and large, I've found that judges are actually quite receptive to education, more so than you'd think. I mean, everyone that I present to who are not a group of judges are sort of skeptical that you can get data on judges. I mentioned yesterday I've collected data on over 5,000 judges. It's not that hard, it turns out, that you have to hit them in the right context, in the right setting. But judges tend to be contemplative about their job. They tend to think about what they do. It varies, of course, and different countries have different mechanisms for selecting judges, and judges have different motivations and the like. But mostly a judge who views herself as a professional trying to get unbiased decision making will actually worry that they're doing a bad job. And if you get them at a moment when they're thinking about it, which I will say is not in the middle of a case. While judges are presiding over cases, they tend to isolate themselves. They tend to close themselves off because they know that lawyers are trying to push them in one direction or the other. Getting them when they're at educational conferences, when they're at academic conferences or in academic settings, I found that they're willing to talk about their jobs. They're willing to think about mistakes that they like to make. And if they're being honest, they will admit they've made some, particularly more experienced judges. So that's a good moment to get them. If you want to get access to judges, I would tell anyone, partner with a judge. That is, judges worry that academics think poorly of them, at least in the United States they do, or that they're just trying to criticize them or just trying to make them look bad. But when you have a partner who is a judge, which I've been fortunate. I've had for 20 years a judge who I've worked with in the United States, and I've worked with many others. That's really a key to getting access to judges. If you have something that you feel that your judiciary needs to hear that's important to them, you don't have to convince every judge that they need to hear it first. You need to convince one judge, one who will work with you to get access to other judges. Judges listen to each other, much more so, of course, than they listen to anyone else. That's not really different than any other profession, but it's a very helpful strategy to get judges. I would say that the other thing, and I don't know the system in Mexico very well, and I apologize for that. In the United States, each of the states and our federal system have judicial training or judicial organization offices that conduct judicial education. New York has one, and I'm very good friends with them. Our Federal Judicial Center conducts all manner of training for judges. Typically, training is focused on getting judges to know the law very well, or keeping them up to date with changes in the law. What I've found, interestingly, is that judges actually get tired of educational conferences that are about the law. They feel they need that, but they get a little bored with that. And for me, I've been very fortunate in being invited to one after another judicial education conference in the United States and at the federal level, partly because I'm apparently regarded as mildly entertaining for the judges. Psychology is something different for them. It's not, another description of new rules of evidence, which they will have to learn, and they will find a way to learn, but they get a little bored with that. 2 days of listening to new evidentiary rules, and they've had enough of that, and they want to hear about something different. And psychology is something that's very different for judges, and so if you're giving people things that are different than they've already heard, and it's not preachy, that probably doesn't translate well. You're not talking at them, trying to convince them they're biased and make them look bad, but trying to improve their decision making. Then they're willing to listen to it by and large. It is a mistake, in fact, to simply lecture to judges on how bad they are. I've made that mistake early on in my career. You don't get invited back if you do that. But the key theme should be to improve decision-making for judges. They're very good at listening to that. If you do have to convince them they make mistakes, but in fact, if the focus is on improving what they're doing, they're pretty good at it. Overall, what are pretty good debiasing strategies? I've given you one very specific one on anchoring, and one sort of very general one on confirmation bias, which is just to get judges to think more carefully, to look at logical structures. But overall, a more helpful thing to tell judges is to look for particular scripts, to sort of write out what they're supposed to do in particular cases. Interestingly, new judges really crave this. Right, so if they're presiding over a particular kind of criminal's case for the first time, what they'd like is a set of questions they're supposed to ask, a set of procedures they're supposed to engage in. Many judicial education centers give judges this already, right? So in this kind of case, you should be looking for this, you should do this first, then do this, then do this. New judges especially are looking for things like that. This is a helpful debiasing strategy too, to have particular scripts or checklists of things to be looking for in a case that are uniform, that are common across cases, that don't allow them to rely on their gut instinct or their intuition. Those are very helpful things to tell judges, and they like to hear that because judges are often very uncomfortable on the bench, particularly with a novel case. I have found, by the way, that new judges in particular, newly appointed judges, tend to be nervous. They don't want to show it because they feel that weakness in front of the lawyers will cause problems. They're right about that. But they are a little nervous about their jobs, and it's a moment at which they like to hear, how am I supposed to do my job? And what I tell them is to look for standard scripts, standard checklists for their cases, because that will take them away from their intuition. And then you have a way of sort of influencing what they think of as a script. This is a strange item. I tell judges hate multi-factor tests. What do I mean by that? Many rules of law involve weighing or balancing 4 or 5 different elements against each other. Right? My students hate that. Well, leading up to the exam, my students like multi-factor tests because they can memorize what they are, write them on the exam, and they know there's no clear answer. So they can't be wrong as long as they identify the right factors. Judges, however, hate multi-factor tests because they actually have to make a correct decision. Right? And if you're weighing 4, 5, sometimes 8 different factors in a case, it's hard to know how to balance all that and hard to get it right. And so they resist that. And there's a fair amount of evidence that judges often will make decisions on 1 or 2 factors rather than 8 or 9 in a case. There's some really good empirical research on this, that in areas of law with our multi-factor tests, judges really only focus on 1 or 2. That's a mistake because it means they're relying on their intuition. What I tell judges is work through each of the elements. Even if you don't know how to weigh them properly, working through the different factors that guide a case in different directions requires you to think carefully about the case and see something that maybe you didn't see before. There's a reason legislatures and higher courts have identified 5, 6, 7, 8 factors to be considered. It's because they're all important, and judges ignore them at their peril. So I try to encourage judges to work through those. One thing I tell judges, I'm misspelling on there. Sorry, I wrote this morning. Written opinions. Telling judges to write out their opinions or write out justifications for decisions are one of the most helpful debiasing strategies you can think of. System 1 decisions, ones that are really arise from intuition, are very hard to justify in writing, right? If all you really have is a particular feeling about how a case comes out, that feeling might be very hard to articulate. And so many judges have told me after listening to my talks that they have encountered cases, and I'm not sure this will translate well, but in which the opinion won't write, is what they say. Meaning they try to write their opinion, but they can't. They can't find a good way to justify their conclusion. And I tell them that is a really good red flag that they've decided the case largely on intuitive judgments, and that in fact they should second guess themselves more. They should write it, they should rethink their decision, not just try to write the opinion so it works, but rethink the decision from start to finish. And that's a really good strategy for judges. I tell judges, even if you're not going to publish the opinion, even if you're not going to show it to attorneys, even if you're not going to use it at all, but to write out just a paragraph justifying to yourself, as it were, your decision, then you're really, that's a good system 2 check on a system 1 deliberation. Writing is all system 2. It's hard work, and it really requires deductive logic and attention to the rules. Okay, so I'm going to switch gears a little here, so maybe that's a moment to pause.
¿Alguien quiere hacer alguna pregunta en este punto o seguimos? A ver, por acá, 1, 2. ¿Micrófono alguien nos presta, por favor? Porque creo que si no, no escuchan en la traducción.
Oops, go back.
Profesor, hay evidencia que sugiere que bajo ciertas condiciones el razonamiento colectivo mejora el rendimiento de los sujetos con respecto a algunos sesgos. ¿Usted ha probado eso, ha comparado eso, el razonamiento colectivo con el razonamiento individual en jueces?
That's an excellent question. We have tested that very recently. I don't have published results yet because we've just started doing that in the last 3 or 4 years. The tentative answer is yes on certain types of problems. So on problems that have a clear logical answer, like the confirmation bias, then in fact collective decision making is better. The reason being, it basically only takes one of a group of people to identify the correct answer, and they can explain it to the others, right? So if you have 3 judges deciding a case, or looking at one of my hypotheticals in my research, if one of them identifies a flaw in reasoning in the other two will accept that. and they'll make a better judgment. So you really only you have, in a sense, you have 3 chances to get it right. Is a good way of thinking about it. We've also tested group decision making with anchoring, and not found much of an improvement. Unfortunately, with anchoring, one of the problems is that groups tend to be more extreme than individuals in making numeric judgments. There's a phenomenon called group polarization, which tends to produce more erratic decisions on numeric estimates. And so the group, in a way, is actually a little worse than individuals. But on logical problems, actually, there's real improvement. So we've delayed studying that for a long time in our research, partly because it does not give judges a clear reform that they can engage in. So in the United States, cases are assigned to a single judge. That's gonna be true pretty much as long as I'm alive. That is embedded in our system of justice. There's just no way at the trial level we're going to have 3 judge panels. Or something like that. In other countries, however, and I guess I wish I knew more about the Mexican legal system. 3 judge panels in the Netherlands, for example, are very common in criminal cases, and that's a system that works very well in other countries. In the United States, we don't have that system. We're not going to have that system. So I tell judges they should rely a little bit on their clerks, on the people who work for them closely, ask them what they think. Is a way of creating a kind of group deliberation. But it's a great question. It does help on some of the logical problems.
Tenemos otra por acá, ¿no? Acá.
Buenos días. Doctor, le agradezco sus amplios conocimientos. En nuestro país, usted... como bien lo sabe, en los Estados Unidos, considera que, por ejemplo, la toma de decisiones, por ejemplo, en cada estado, mientras que en un estado es un delito, en el otro estado no lo es. El sesgo, yo considero que cambia, no se puede aplicar el mismo, porque por ejemplo en nuestro país, en México, partimos de un federalismo. Es un estado, una federación, somos Estados Unidos, de ahí el nombre, mexicanos. Entonces aquí precisamente hay esa problemática de que, por ejemplo, los jueces no se ponen de acuerdo en la toma de decisiones judiciales, a pesar de que tiene que tener una actualización y una argumentación jurídica. Deben de tener un método que es una doctrina, y como bien lo mencionó en su discurso, es difícil aplicar el mismo método en los Estados Unidos que en México. ¿Por qué? Porque mi opinión difiere cada estado en la actualización digamos, de la Corte. ¿Por qué? Porque precisamente nuestra Constitución, por ejemplo, en México, es muy restringida, digámoslo, nos restringe nuestra legislación para poder aplicar. No se puede el juez ir más allá. En cambio, por ejemplo, en Estados Unidos es digamos, mientras
Trata de hacer como muy concreta la pregunta.
Sí. Concretamente sería, usted considera, por ejemplo, no sé qué tiempo certifiquen la actualización de capacitación de los jueces en Estados Unidos. Aquí en México, o sea, precisamente tenemos esa problemática en la toma de decisiones judiciales. No sé qué, como usted bien lo dice, forman una comunidad de actualización como usted con lo mencionó, capacita a los jueces, ¿no? Entonces, se repite esta problemática igual aquí en México.
Yeah. Did you get that?
I think so. There's a lot in that question. So, at the outset, one of the concerns is that. So I'll start now. At the outset, one of the concerns is that the cognitive errors or biases I identify in one group of judges is not necessarily one would find in a different group of judges. I partly agree with that and partly disagree. So I partly agree because cognitive errors are a product of the information being presented. And so a different legal system will present information to judges in different ways. So, for example, as I was saying, in the Netherlands, the judge directs a lot of the proceedings, whereas in the United States, the judge is much more passive. And to me, that means that confirmation bias is more of a problem in the Netherlands than it is in the United States, because in the United States, the judge will be exposed to evidence that he or she does not particularly want to see, whereas in the Netherlands, they can actually avoid it. They're aware of that, so they actually try to train their judges in a way that addresses that problem, and we don't. So our judges are vulnerable to the problem because I think they don't see it as much. And most legal systems do recognize basic errors in judgment that their judges make and try to remedy them in some way. So the system itself might produce biases or avoid them based on what the system is. Systems of justice that have multi-judge panels at the trial level, as the last question suggested, have sort of an innate debiasing process in them. You're getting 3 different opinions, sometimes 5, as opposed to just one. In the United States, we just have one, and that creates its own problems. And so it's important for any legal researcher to be sensitive to the system they're working in. But the human brain is still the human brain in different systems. So the part where I disagree is that there's an overall tendency that psychologists have documented in human beings to rely too quickly on first impressions, on intuitive judgment, and less on careful deliberation. That's an overgeneralization, and I hope the psychologists in the room are appalled by that overgeneralization because it goes too far. But in fact, that when one talks about how judges work, that's kind of, if one were to summarize the work I've found and others have detected on judges, that really does summarize it, that they rely too much on their first impressions. A careful legal system might remedy that. There might be processes designed to slow the judge down or make him or her think carefully. Or there might be training that slows the judge down. Like in the Netherlands, they are worried about confirmation bias. But that tendency is still there. And particularly if we're going to talk more about implicit biases about people, that seems to be almost ubiquitous. Humans make quick judgments of other human beings, regardless of where they are. Their biases might be different, so which groups are thought of as disfavored or discriminated against differ in different countries, but we all have our groups that we disfavor. And so that tendency is ubiquitous. And you asked about judicial training. Well, interestingly, in the United States, the training for new judges is almost non-existent. We appoint judges from among groups of experienced lawyers. So in the United States, once in a while we'll have a student who says, what I really want is to be a judge. And I have to tell them, you need to wait about 20 years. And I give some advice on how they can make themselves, create resumes that will make it possible for them to be appointed or elected to be a judge. But it takes, we appoint from experienced lawyers, but then give them no further training in how to be a judge at all, or almost no training. New York State has a new judges education program. It's 5 days long. That's it. The federal system has a judge education training program. It's 10 days long. And typically it's undertaken after the judge starts being a judge. We don't take seriously the idea that there is a particular art to judges that we have to train. That's very different in continental Europe, where judges are trained often for a year or more before they can be a judge. But training after one becomes a judge is very common in the United States, mostly, as I said, to keep abreast of or keep apprised of new systems of law. I don't know what you have that's comparable in Mexico, if anything. I would say that really all judges need that, really, regardless of what country they're in. It would improve judges to spend time both learning new parts of law, but also thinking about their jobs, particularly with other judges. The Canadians are very, very good at this. They have a conference for judges that are experienced between 5 and 10 years, that they try to get all of their judges to attend. It's kind of interesting to take judges who have been on the bench for 5 years or more and try to retrain them, but they have a week-long conference for them, and it's mostly taught by other judges. So it's kind of like peer review, judges talking to each other about their jobs, and they do a very, very terrific job of this. It's really quite remarkable, where they have judges willing to identify what they think they've done wrong over the last 5 years, and they really focus on that. It's almost like a remedy for the confirmation bias. It's something I really, really quite admire for them. I guess that's a long-winded answer to a complicated question. I'm
Okay,
sorry.
una más y continuamos. A ver, por acá, el micrófono, porfa.
Thank you very much for your talk. We have some preliminary results that indicate that judges make and justify decisions according to mental models that include different models. Sometimes they justify based in the rules of law, sometimes in implicit theories, sometimes in heuristics, etc. I wonder if you are making some experiment about the impact of biases in the semantic reconstruction of the rule of law and the assessment of evidence and the reconstruction of the discourse of facts. Because I suppose that biases can have impacts, different kind of impacts in different models of these complex mental models. I wonder if you have some experiment in
Good.
it.
Thank you for that question. So that the question itself points to one of the principal flaws in how I present the work, sort of system 1, system 2, because it overlooks the possibility that once a judge has an impression about how she wants to decide a case, she then might adopt a particular way of thinking about that case that would justify that outcome. And this framework of sort of system 1 and system 2, I think, does not really address that, because it can give the judge the illusion that she's debiasing herself with careful reasoning, but that careful reasoning is all entirely motivated to achieve a particular result. So I accept that as a serious criticism of that methodology. We have done some research on that problem that I think speaks to your question. We published a paper a few years ago on motivated reasoning in judges, and there are a few other people that have studied this as well. The idea being that if our research question was, would a judge basically alter her legal reasoning to achieve a particular outcome for a more or less sympathetic party? So what we did is we gave judges hypotheticals in which we asked them to make a legal ruling, to rule on what a law meant, to interpret a particular law. And what we did is we changed the litigant to be very sympathetic or very unsympathetic in a way that should not affect their legal ruling, that really shouldn't alter how they think about the law or the precedent. That should all be deductive logic. It should all really have nothing to do with who the litigant was. But it had a lot to do with who the litigant was. The more sympathetic litigants, the judges were willing to bend the law very heavily in their favor. The less sympathetic litigants, they were not. It does suggest exactly that the judges will really engage in what psychologists sometimes call motivated reasoning to try to suit particular outcomes. I don't have a good debiasing remedy for that because partly I'm a little agnostic on whether or to what extent that really is a bias in the system. It sounds like one the way I phrased it. Judges are making legal rulings that should have nothing to do with their sympathy for a party, but they do. That sounds like a mistake. But many of our problems in particular involve very sympathetic litigants. And I've had a few judges say to me afterwards, well, I ruled in favor of that party, even though it really bent the law in a way it shouldn't be bent. But, you know, you can bend the law and it's not going to break. Oddly enough, more experienced judges are more willing to say that. New judges don't tend to do that. And what they're sort of hoping for is that the system will sort of bend it back, as it were, right? So that if they create exceptions for highly sympathetic litigants, it won't lead to a distortion in the legal system overall. That's, I think, maybe a strange answer, because I think we'd like judges to judge the law as it is, and then if they need to make an exception, to identify that as an exception. And they don't do that. They just bend the law to suit the outcome. That said, another partial response is to look at the sort of magnitude of the effect that I observed. It depended on the case, but most of the judges ruled the same way most of the time, regardless of the sympathies of the parties. So you'd see maybe a third of the judges or a quarter would shift their decision. So by and large, they would be making rules, legal rules that were the same regardless of the sympathies, but a few would sort of change their minds, maybe a quarter or maybe a third. And maybe that's not a terrible system, right? Particularly if you've got, what we did is we manipulated the sympathies of the parties to the extreme. Some of our litigants were highly sympathetic or highly awful. And if that changes the decisions of a quarter or a third of the judges, maybe that's empathy combining with formal legalism. And so I kind of like the outcome, but I basically agree with the thrust of the question that I worry here that System 2 is not a cure-all for everything. It's going to be motivated by System 1.
Nada más quisiera yo, digo, porque me parece la pregunta interesante y creo que hay algún elemento que creo que está ahí presente y que tiene que ver con el lenguaje, ¿no? O sea, cómo el lenguaje también que se está utilizando para una justificación legal puede tener algún sesgo, ¿no? ¿Hasta allá lo quieres llevar también? ¿O por qué no nos das un ejemplo un poco de qué es específicamente lo que están midiendo? Porque yo lo que entendí es que también tiene que ver con cómo está construido el lenguaje legal, ¿no? Y la forma de justificar.
Sí, en algún sentido. Lo que estamos haciendo es una investigación en neuroderecho.
Ajá.
Entonces, básicamente lo que tenemos a través de equipo electroencefalográfico y electrodérmico, con un conjunto de estímulos que son preguntas que corresponden a 4 variantes del mismo caso, una variante en la que solo hay que hacer un juicio moral, hay que determinar cómo resuelves un dilema moral, solo aplicar la ley, o resolver un dilema jurídico-moral, y tratamos de ver cuáles son los correlatos neurológicos que están operando y electrodérmicos. Lo que hemos encontrado, porque además les pedimos después la justificación de la respuesta, lo que hemos encontrado es que en ocasiones te responden con base en lo que dice la ley. Por ejemplo, había un caso del que les decíamos, un agente de seguridad tortura a una persona, tiene la certeza de que es terrorista, que él sabe que se va a poner una bomba en un centro comercial, que van a morir muchas personas. Entonces, algunos respondían, la pregunta es, ¿lo sancionas o no lo sancionas? Después de presentarle el artículo correspondiente. Algunos respondían, no lo sanciono porque los tratados internacionales dicen que bajo ningún concepto se puede torturar. Pero ahí lo que tenemos es un módulo de razonamiento técnico jurídico. Pero algunos otros decían que sí, que no lo sancionaban o ponían la sanción menor, considerando que habían evitado la muerte de muchos inocentes. Entonces, en ese caso, el modelo mental no está operando con base en el modelo técnico jurídico,
está operando con base en las creencias morales del sujeto, y esto es lo más interesante que queríamos mostrar, es un poco el debate Dworkin-Ras. Queríamos mostrar que en algunas ocasiones los módulos de creencias morales pueden derrotar a los módulos de carácter técnico-jurídico. En otras ocasiones, las respuestas tenían que ver con experiencia subjetiva. Entonces, otra de las fichas decía, una señora escucha que entran a su casa unos sicarios, tiene algunos niños, uno es un bebé, trata de evitar que el niño con el llanto alerte a los sicarios para que puedan subir y matarla a ella y a sus otras hijas, y las preguntas era, ¿sancionas o no sancionas? Primero la pregunta es, ¿hizo bien o hizo mal? Para ver el módulo moral, y después preguntaba, ¿sancionas o no sancionas? Uno de los jueces, por ejemplo, lo que nos dijo, si me hubieras hecho esta pregunta hace 2 años, te hubiera dicho que no lo sancionaba, pero hace 1 año que soy papá. Entonces, ahí se activó un módulo de carácter subjetivo, de experiencia subjetiva. En ocasiones lo que hacen es que después de esto buscan estrategias para la construcción de argumentos justificativos. Entonces, la pregunta va dirigida en el sentido de si habían hecho ellos alguna investigación acerca de qué manera impactan distintos sesgos en distintos módulos, porque a veces el sesgo te puede llevar a dar una interpretación distinta a la ley. Por ejemplo, si tienes un término afectado de vaguedad, mueves la vaguedad a un lado o al otro, o si, por ejemplo, te lleva a darle pesos epistémicos distintos a las pruebas. Ahí tenemos otro ejemplo, que no es de este experimento, es de otro. Preguntamos en el caso de pensión alimenticia, algunos jueces, ¿qué peso le dan como prueba a los tickets de compra? Entonces un juez nos decía, yo no le doy ninguna. Otro decía, los pego y analizo, y si el patrón de compra corresponde con lo que se compraría para un bebé de tal edad, le doy un peso indiciario. Y otro decía, que este fue el más divertido, depende, si no me alcanzan las pruebas que tengo, les doy valor indiciario. Entonces, ahí podrías estar viendo que hay alguna especie de sesgos previos, con base en su experiencia, que están determinando qué haces con las pruebas. Si no me alcanza, quiere decir que pues, tengo que ver que me alcance y en este momento le doy más pruebas. Entonces, la pregunta era el impacto de si habían estudiado el impacto de los sesgos en distintos módulos, no nada más una decisión aislada, y desde luego, creo que aquí puede ser muy importante la presunción de motivación distinta del derecho estatutario en el ámbito anglosajón y en el ámbito de la tradición romano-germánica. Supuestamente la motivación en nuestra tradición positivista sería más raciana que dworkiniana. Lo que creemos es que no es cierto. Entonces, en ese sentido, yo me voy a tener que ir porque tengo otro, pero me encantará después estar en contacto contigo, seguir en contacto y ver qué podemos hacer conjuntamente. Bien, muchas gracias.
Absolutely.
I think he's giving a little bit more information about his question. So, would you like to give an answer different from the one that you gave before, or should we go on?
No, I just want to say I really like the kind of research, and I please send it to me, and we should certainly be in touch. What I like about I like a lot about what you're doing, but one of the things I like is the idea that judges are selecting different theories for how to approach, and there are different kinds of theories that they select. I've long thought that, and we have a design for a study that we've never run because we need a large group of judges and all at once to do it. It's a little challenging. Where I think what we could do is push judges into different modes of thinking. There are in the United States history, judges who are associated with different kinds of legal reasoning. So some are associated with legal realism, who tend to try to take all things considered, who maybe are a little fuzzier, and others who are more formal and more rigid. And what I've wanted to do is just give judges examples, little biographies of the judges, and then give them a case to see if that then pushes them into one way of thinking or another about a case. And it sounds like you're way ahead of me on this kind of work, so I'd love to see it.
One of the questions at the level of metadata is what is the legal theory that you follow? In order to see what is the
Oh, sorry.
What is the correspondence between the implicit theoretical belief and the outcome of the response? For instance, if morality is not quite important in the response,
right,
and the support is in the rule of law, and if has said, I am a just naturalist, there is a kind of theoretical contradiction in the way of processing information. That is, we have considered that variable.
I think that's right. And so in the data we have where we vary the sympathies of the parties, I think those judges who are reaching decisions that are favorable to the more sympathetic litigants, at least some of them are adopting a theory of law that is law as a moral agent, just sort of all things considered, getting everything right. Whereas judges that are ignoring their sympathies and ruling against the sympathetic party are adopting a very formal, more or less jurisprudence of law and approach to it. And I think that does distinguish what our subjects are doing, although we didn't investigate carefully what their reasoning was. We just have the raw dependent measure, who did you favor, plaintiff or defendant. So we didn't address that, why we get these differences in the way that you're addressing in a much more sophisticated way.
And I finished. Something that we would like to do also is, what is the relationship between attention and the different models?
Yep.
I think that is a very important question.
Good. No, I agree.
We'll keep in touch. Thank you.
Yes.
Okay, so we still, tenemos todavía unos, you want to go ahead with the next part of the presentation and then we have a coffee break?
Oh, maybe this would be a good moment for a coffee break.
Yeah, I don't know, is the coffee, ¿está el café listo? ¿Sí? Ok, ¿les parece bien si hacemos como una pequeña pausa de 15 minutos? ¿Sí? Para estirar las piernas, tomar un café y seguimos en la siguiente parte.
I'm so glad you came to this. Nice to meet you. Yes, a very great pleasure. Excellent.
I must go to another.
Oh, yes, it happens.
Yo me imagino que eres Enrique Cáceres. Ok. Sí, ya